SJC-13664, Commonwealth versus Antonio B. Nascimento-Depina.
Attorney Benyon.
To the Chief Justice, and may it please the court. I think we're here to talk about the Arizona case that came down last year.
Are you going to have a fair victory here?
We'll see. But I think the case is pretty clear and on point. So when we're talking about the Sixth Amendment confrontation clause...
Because I want you to address prejudice. I want you to address prejudice. That was my smart alecky way to ask you to address prejudice.
Oh, all right. So in this case, we have the complainant who makes the allegation. The prejudice here is what the DNA test does is it kind of gives credence to her testimony, even though the blanket is from his bedroom and it's not.
I thought during the trial, it was the defense attorney said, I'm going to put this stuff in anyway.
You're talking about the
DNA report, et cetera. I mean, so it basically shows that there's biological material in the defendant's own bed,
yes,
which isn't a shocker, but none attributable to her,
right,
where the sexual assault occurred,
right,
which corroborates his defense in some respects, right?
The whole defense. It's the whole defense. I mean, this is not one of these cases where we have to look at the trial transcript and read 40 pages of closing argument. There's 3. And the entire closing argument for the defense is, thank God the police took the blanket and thank God they tested it, because it shows none of the DNA of the complainant in this case. And so it corroborates everything that we're saying, that this never happened.
Yes, that is one way to look at it.
What other way is there to look at it? That's the trial counsel's own words.
So the other way to look at it is that she explained that she saw quote unquote white stuff coming out and on the bed, and the reason this was brought forward by the government was to show that to aid her credibility. It wasn't just for the defense. I mean, there's a reason why the government brought this in.
They didn't want to bring it in. They were satisfied to not call this witness at all. And then faced with the inevitability that the defense was going to call, that's why they called. So this wasn't necessarily something that the government came charging in and say, we want to call this substitute analyst.
Again, this is not a defense witness. This is a government witness. This is and the reason I think is you draw from the transcript.
Was the witness not on the defendant's list?
I don't recall offhand. It's been a while since I looked at the pretrial.
That seems important if you're representing it wasn't a defendant's witness.
Well, it was the defense that brought in the, I'm sorry, it was the government that called the witness and put them on the stand. There was discussion pretrial about how this witness would be brought in. There was plenty of discussion. It seems inevitable that, the substitute analyst would be allowed to testify, and that's what she did. The problem here, and the red flags that I'm here to raise, are with respect to the Sixth Amendment. But with respect to prejudice, anytime you've got that scale where you're a juror, a lay juror, and you're looking at who the government is bringing in.
Why did the defense attorney put in the substantive report?
I think it was to call attention to the problem of confrontation. In other words, he had discussed the fact that the substitute chemist had not done anything on the...
I know you're here to talk about the Sixth Amendment violation, and frankly, you have a good Sixth Amendment violation
But you want
case.
prejudice.
But yeah, but I think what's important for this case is the issue of prejudice.
So from my client's point of view, from my point of view as a defense attorney, again, it's the government's witness. You can say that it helps the defense, but that's not the way a juror would...
We don't say that. I think defense counsel said that. I'm looking at the closing argument, and it's pretty clear that defense counsel was relying on the DNA from the substitute analyst.
Yeah, but evidence has different ways of being looked at. Each side gets to argue. I mean, the government gets to argue that the DNA evidence supported the complainant's testimony. The defense attorney obviously is going to say, well, there was none of her DNA on it, but
So it's your argument, basically, he was putting the best spin on it that he could.
he was. And that's because there was nothing that was going to keep the substitute chemist from testifying. And so that is all you can do.
Can I ask you about the nature of the error, so the Sixth Amendment issue itself? So Smith v. Arizona doesn't preclude, for example, a substitute, as I read it, a substitute analyst from testifying
Right, it
entirely.
does not.
It does not. It says that it still allows forensic experts like the expert there to play a useful role in criminal trials because that expert worked in the same lab as the first expert. He could testify from personal knowledge about how that lab typically functioned, the standards, practices, and procedures it used to test seized substances, as well as the way it maintained chains of custody. And then it expanded even further on what a substitute analyst can testify to. Now here, this is not simply a substitute analyst. This is the second-tier analyst within the same lab. And she testified not only to the practices and procedures, a lot of her testimony was based on her knowledge of how the lab did its work. I take it you're not challenging that under Smith v. Arizona, correct? I also assume you're not challenging her ability to testify to what she did as the reviewing analyst, correct?
That is correct.
All right, now that was a quite detailed description of her duties when she explained what it was that she did, because she says she checks the math, she checks the validity of the testing results. And so if we're not challenging that, I guess my specific question to you is, what specific portions of the testimony, it would be helpful to me to know the page numbers and line numbers, of the testifying witnesses' testimony, do you contend were erroneously admitted under Smith v. Arizona?
Great question, thank you. So, yes, so if you have your transcript, we're on volume 5.
I'm going to pull it up.
All right. So I want to first we'll start on page 61, halfway down the page. And I agree. So she is able to testify because she works at the lab as to the procedure. She does that. But again, to the best of this is the question from the transcript, to the best of your knowledge, the information was the 4-step process, and about the procedures, was that 4-step process undertaken in this case? Yes, it was. But we don't know exactly what the underlying analyst did, because
That's the same testimony in Smith, except it was a 3-step process in Smith.
yeah, something similar. But so I'm not. What my
So
concern
I'm looking
is,
for what was erroneously admitted, not what was correctly admitted, but the specific
so
pages.
it's those calculations that, even though she did them, they're still based on the underlying chemist's work, and it's those calculations that firmly place my client's DNA.
Why would pages 62 and 63 be excluded under Smith v. Arizona?
62 and 63, I'm not sure that they would.
Okay, so which pages would be, or which lines?
So I think you're looking at 68, where she's testifying as to the end results of the calculations.
So can I interrupt you right there? So isn't it already the case, even before Smith v. Arizona, under, I don't know how we pronounce this case, but Greinader, that a substitute witness cannot get up on the stand and just testify to results. A substitute expert can get up and testify to her opinion on direct examination, and then on cross-examination, potentially, the results can come in.
Yes, that is.
So you've made an argument that you should not be subject to the substantial risk of miscarriage of justice standard of review here, because under Vasquez. But isn't that not true? Because at the time of his trial, it was already clear, even before Smith versus Arizona, that everything on page 68 should not have been admitted.
So I think that the Supreme Court's case, and Justice Kagan even admits this, the difficulty here is that there's a breadth of interpretation as to the way courts have looked at Williams.
But this court had already looked at Williams in Grenadier and had specifically said an expert can give her opinion, but may not on direct examination recite another analyst's data, correct?
Yes. In this case, though,
That's an evidentiary violation.
It's
so
hearsay.
Going, it is an evidentiary issue, but going back to Kagan's Smith opinion, she says, even though you can look at this as a violation of evidentiary rules, what you're really looking at when it comes to confrontation is whether there was confrontation, whether there were those two steps that came. In fact, I can even pull it up for you.
Well, the first part of Smith, back to Justice Dewar's point, I mean, I think you're overstating it a little bit, because that's always been our law, right? I mean, the first part that they decided was a dispute amongst which, in the federal rules of evidence, whether or not the underlying basis for the expert's opinion was either coming in to inform that opinion or whether it was coming in for the truth of the matter asserted. We always said that it was hearsay. We've never wavered from that. And so so that wasn't anything that changed anything about what we were doing in any event. Okay. So where do we go from here, at least in terms of what was testified to versus as a substitute chemist versus what she could not do? So I really, back to Justice Wolahojan's point, I think that if you could focus on me for a minute.
Okay.
What confused me and what I thought was the issue with the confrontation issue was there was a melding, even though she claimed to have done all of the review of the initial analyst work and independently looked at all of the calculations and all the conclusions. But when she was asked to testify to them, she kept using the pronoun we. And I think that's really the problem here with at least what she says. And sometimes specifically, if you look at volume, page 67, she says, yes, she did. So that's the part that seems to be a real problem here. Is that the issue here, that we don't know what she testified to based on her own independent review of it versus her parroting what the initial chemist did?
Yes. And I think that's one of the reasons why defense counsel, if you look at what he said, is, well, if this is what she's just going to parrot, then let's just put it in. And that gives the kind of interesting back and forth between the defense attorney and the ADA, where the ADA was actually objecting to putting it in because it was hearsay. And so, yes, I completely agree. We don't know exactly what she brought out. And in fact, it just seems like she's parroting, and defense counsel says she's just parroting the report. But it is that report. But there are portions where she says, I think she says, I did the calculation, or I double-checked the calculation.
She did. On volume page 62 to 63, she lays out everything that she did independently of what the initial analyst did.
But the testing is, the calculation relies on the testing that was done by the underlying chemist, and that's the problem here, because defense counsel was never given a chance to cross-examine her with respect to how she conducted it.
She could have said, this is my job, this is the protocol in the lab, I reviewed all the bench notes, and this is what I did as a second-tier analyst, and my opinion is that the DNA matches the defendant's sample, right?
Yeah, but she didn't do the testing.
That's what Alito says you can do, and Kagan's a hypothetical person, but under our case law and under the now Supreme Court law, that's okay. The problem is when she agrees with and she parrots. I get that, but she's allowed to at least give the bottom line.
This case, she does get to say what she did. I agree. But she can't,
My opinion is there's a match. She can say that, correct?
no, I don't think she can say that. Because she didn't do the test.
That were performed by someone else, which I reviewed by doing X, Y, and Z. It is my independent conclusion that there was a match.
Because you're still
It
missing,
may be infirm, it's subject to cross-examination. You're going to be able to cross-examine her opinion.
yeah, you can cross-examine her opinion.
And you say, well, you don't really know because you didn't do the testing.
Yep, that's what
So
hopefully,
your view is Smith precludes the use of a substitute analyst?
to testify as to what the underlying analyst did,
No. Under Smith, can a substitute analyst testify?
Yeah.
The medical examiner has died 6 years ago. It's a cold case. Can a substitute analyst testify?
as to what she knows, like, for example, what the standards are, what the processes are. If she double-checked the calculations, that's fine, but it still goes back to what the underlying chemist did. And in this case, we know that it only takes 10 days to actually test the DNA. If the government was going to call this witness.
So isn't your answer to Justice Gaziano's question that you can't as a substitute? Because you're always going to have that.
I'm sorry, you're always going to have the substitute chemist?
You're always going to have a substitute chemist that you can go backwards a couple dominoes and say, the only reason why you get to confirm or reaffirm what the first person said was if we accept what the first person said is true.
Right.
And so I'm always going to need, as a matter of confrontation clause jurisprudence, I'm always going to need to be able to cross-examine the first layer that isn't there. So what is the scenario where you can do this?
Where you can do,
Where you can call a substitute analyst, a substitute expert?
it depends on what you want to use.
But let me just give you a hypothetical.
Okay.
There's a cold case, a murder case. The victim has been stabbed 15 times. The medical examiner has passed away, the original medical examiner. New medical examiner gets on the stand. New medical examiner says, I work for the Office of Chief Medical Examiner. I looked at all the photographs that were available in this case. I looked at my predecessor's notes and sketches, and it's my opinion, based upon my review of this file, that the victim died from stab wounds. Is that permissible?
That's an interesting hypothetical. And I guess I would say a court would have to make a determination as to like where the stabbings occurred and what, I mean, you can get with such technicality. I mean, as lay attorneys or a judge, okay, stab wound.
And the defense attorney can get up there and say, well, these are superficial stab wounds, and open up all those doors that we talked about in Grenadier and Barboza, et cetera, and Hamey and DYS versus Juvenile and all those cases. But the bottom line is, can't the medical examiner say
So in your hypothetical, it's the cause of death. Here, it's pointing the finger at my
Can
client.
you answer my hypothetical? Is that permissible testimony under your view of Smith?
I think it would depend on to what extent the cause of death impacted the client's confrontation right. I mean, I get it. You have a stab wound, it's likely going to cause the death, and regular people can understand that.
Read what Kagan says and what Alito say. Kagan says you could do that by posing a hypothetical. Alito says you can do it just the way I proposed it. Is that not the law?
There's a reason why there's a confrontation clause in our Constitution. And
So I think what you're posing is a bar to substitute testimony.
no, because I think there are reasons why a substitute would come in to testify. I'm not saying that they always have to be barred. Again, the substitute testified as to procedure, what goes on in the lab, that smacks as fine to me. It's the problem that she has to get
You have the problem with the conclusion. Why would you call a witness who's not going to offer a conclusion?
That's a good question.
The hypothetical about the medical examiner is importantly different from the DNA context, right? Because if you have a medical examiner who has at her avail a substitute medical examiner who can look at photos, who can look at primary evidence, essentially, herself, and then draw her own conclusions. Even though she's a substitute and she didn't get to examine the dead body in person, she can draw certain conclusions from that, correct?
Yeah.
And I think the question is DNA evidence similar in that a substitute examiner can look at the materials that exist in a file and state an opinion?
And counsel, before you answer that question, because it's a corollary to this, to Justice Stewart's question, we've said before that DNA is actually better than the autopsy because you leave out the subjectivity and it's more mathematical and it's more scientific. And there was an actual, I forget what Chief Justice Gant said about the perverse reaction of saying, because it's better, we should keep it out. Was that Barbosa? I think. So what do you say, marrying those two concepts?
I'll do my best.
Please.
Just because somebody, and we know this, especially in Massachusetts, because of drug certificates, and there are reasons why an analyst who can be viewed as a bureaucrat who would never do anything to, because it's so clean and pure, she's just doing a calculation, she's running a gel, that's all you have to do is run electricity through the gel. And there are reasons that people do things that we don't understand. There are reasons why there are biases, there are procedural rules that aren't followed.
All of these examinations have underlying data. In a medical examiner situation, there are photographs of a dead body with stab wounds. In a DNA case, there are graphs and STR, frequency calculations, et cetera. That's just data. In a drug lab case, there are spikes that say it's the profile of cocaine or not the profile of cocaine. Can't a substitute examiner, whether it be DNA, drug lab, or ME, look at data and say, I reviewed this data in my opinion, not parroting what the other person said, but my opinion is X?
It's the test. Remember, whoever conducts the test is the focal point and is the person who is pointing the finger. There was a chemist who took cocaine and put it in.
Kind of familiar with that case, but
Yeah, I know. We all are. We spent more than a decade doing those cases. I did myself. Once it's that underlying person. It's not as clean cut. There are people who have biases. There are people who maybe think that they look at this case and they say, oh, rape of a child, that's terrible. This person must have done it, and might think that they might want to help the government. All they had to do was retest the DNA. It was the government's witness. That's all we're saying that they had to do. They didn't do that. This Justice Kagan's phrase in Smith about the bells and whistles of a confrontation clause violation or the red flags, this is what should be raising in your head as you see this case, because we don't know. Everything that the substitute analyst testified to heavily all relies on what the underlying chemist did, and we don't know what she did. We just have to presume that she was a good state employee and just did what she was told.
Do you see? So I'm struggling with I don't like sloppy nomenclature. So I'm struggling with the difference, if there is one. This was not simply a substitute expert. This was an expert who was the reviewing analyst at the time.
Yes.
Right. So I think we need to be there. In Smith v. Arizona, that was not the case. It was someone who had not been involved in the testing to begin with. It was a purely substitute analyst. So do you see any distinction there? I do.
I think I do, in the sense that, but let me say it this way. There were substitute analysts, or not substitute, there were confirming analysts with those Dukin drug certificates. And if Dukin is really moving drugs around as in the primary state, a secondary manager who overlooks that is not going to catch that. That's why confrontation is important. And that's why it's the tester that is important.
So I'm gonna say, I just want to circle all the way back, if I may, to the question about which portions of this testimony specifically do you contend violated the Sixth Amendment. And I heard it's the answer that goes from the bottom of page 67 to over to 68. Is there anything else? And I think it may be perhaps,
69,
well,
70, all those calculations that kind of are the ones that say.
well, she just testifies to general numbers about in the world. But I think maybe 71, basis 71 over to 72. Is there anything else? Because I think that we only look at if we were to determine that there were testimony that was erroneously admitted, it's only when we get to the prejudice prong, we only look at that portion of the testimony, not like in the abstract, everything she said, but only the things that she said that were wrong.
Yeah, that is what you're going to look at.
Okay, so
But you're,
68, 67 over to 68, 71 over to 72, the things that where she's testifying specifically as to what, was it Schneider did?
and I think what she did with respect to the calculations, because she had to rely on, she got those numbers for the calculations because she got those from Snyder's.
Well, she could say, couldn't she, if she gets, some mathematical calculation from someone, she could say, I saw this, I checked it, that was correct.
If the underlying numbers are right, but we don't know because we haven't cross-examined the person who tested them. She's drawing, in other words, she's drawing on Snyder's work to make her calculations. Now, Snyder did her own calculations that are in her report, and Hart parrots them. But again, you still have to rely on what Snyder did and how she did it.
So if Hart just said, I checked the math, and 1 + 2 is in fact 3, that would be fine for her to testify to that. The problem is, she goes on to say, and 3 means such and such about the DNA of the defendant and 2 other women on the sheets. Right?
That's right.
That's the problem, because that's where it requires Schneider's accurate DNA testing of the samples from the bed sheets in order to draw that final conclusion. But she can testify that 1 + 2 is 3, and if that's what the government wants to put on, great, God bless them.
Right. So it's the hearsay, the portion that was meant for the truthfulness are Snyder's numbers, and it's the testimonial part that is the testimonial part is her extrapolating that this is the defendant's DNA.
Any further questions? Thank you, Counsel.
Thank you.
Attorney Mark.
May it please the Court, David Mark for the Commonwealth. Let me start by acknowledging an error in our brief, pages 14 and 20. We represent that this testing was done correctly, that the evidence came in correctly. It did not. Justice Wolohojian, to your question, 67, page transcript 567, lines 19 to 21, it's clear that that Jessica Hart is reporting the underlying result
Right.
of Kira Snyder.
And I think that's also the case later on, right?
Well, look at volume 576 at line 8. Jessica Hart then acknowledges that she has been reading from Kira Snyder's report. That's the statistics she just gave the jury. So that is absolutely not the way you do it, and that was clear long before Smith v. Arizona. That's inappropriate under a long line of Massachusetts cases.
So can you tell us which pages you would concede were erroneously admitted in this fashion?
Essentially, all of her substantive testimony about the likelihood, the frequency likelihood as to.
Perhaps you could follow up with a letter, so you don't have to be more precise. Could you follow up with a letter with your concession of what was erroneously admitted?
Yes, absolutely.
Just page number, page
Yes,
and line
I'll do
numbers
that.
would be helpful.
Can I follow up with a question? Do you think that there's anything in here by Hart that is a statement of opinion?
So as to the question of statistical likelihood, I know that she's, because of her status, I know she's capable of giving an independent opinion on that. I just don't think she did it here because of the way this came in. we took the shortcut. We shouldn't have done that, but I think the reason we did is that it was clearly not contested. There is no objection from the defendant. And then the next thing the defendant does on cross is to put the underlying report from which apparently Jessica Hart was reading into evidence. There's a reason for that.
Should he be penalized for trying to make the best out of a bad situation?
I'm sorry?
Should the defendant be prejudiced by, or be
But I
penalized?
don't accept the premise of that question that he was trying to make the best out of a bad situation. The defense clearly was, so the evidence, the DNA evidence is kind of a package deal. You get the strong correlation to the defendant, but it's, his own betting. And you also get the absence of the victim's DNA on the bedding where she says the assault occurred.
I forget, did the defense attorney say anything about DNA in his opening statement?
I think he waived opening. I didn't
That's
see-
why I don't,
Yeah.
he waived opening?
Yeah.
Okay, thank you.
So,
But the fact remains that the Commonwealth didn't have to put on this witness.
we didn't want to put on this
Well,
witness.
the witness was on the defendant's list, and so the Commonwealth made a strategic decision, potentially, but this is pure speculation on our part, to put on the witness, and did put on, as part of the government's case, a witness who could significantly corroborate the victim's testimony, because the victim said it happened on this spot on the bed, and led them to that spot, correct?
So that is a representation that, oddly enough, defense counsel made in the closing. My recollection of the transcript is the evidence that came in is never quite that precise. She does say, it's clear that they seized the bedding because she has described this occurring and there being evidence on it. But as to that's the spot and they pin it and they take it to the lab and lo and behold, it positive for semen, I don't think that's how the evidence actually came in. But it is clear that she made a representation about what she saw happen and that they immediately seized the bedding for that purpose and to test it. Now, I think what defense counsel was especially focused on was this is a third report, and the reason it's a third report, apparently, is that there was a retest with a more sensitive, newer test, and that more sensitive test also did not produce DNA from the victim, and that's what he highlighted. The defendant was clearly always focused on what was most useful on balance, most useful to the defense, accepting the negative side of it as not terribly damning for the reason that it is his own bed sheets and there's evidence that he was sexually active with another person. So that weighing out seems entirely reasonable, and under the circumstances, he can hardly be heard to complain that he was prejudiced because, as we acknowledge, this evidence came in, it was improperly admitted. It clearly, with Jessica Hart as the both supervisor and the technical reviewer, it could have been done properly, it just wasn't.
So you think it was both an evidentiary error under DYS versus juvenile and a confrontation clause error?
Yes, it was, but it's harmless under the circumstances, yeah. So,
Just so I understand you, could you just please outline for us why you say it was an evidentiary error? Was it because she wasn't being called as formally as an expert? She hadn't been voir dired? What is the evidentiary problem?
the sort of Barbosa-Chappell line of cases lays out the way you put this evidence in properly, right? The thing you don't do is you don't say, here's what the testing analyst said, and I'm the conduit. You can't do that. And unfortunately, that's exactly how it came in here. And then she reads from the report. That also is what you can't do here. She's capable of looking at the raw data and generating her own conclusions about what that data means, and she didn't do that. I mean,
She didn't testify that that's what she did?
I
mean,
clearly
I'm not going to quibble with your concession, but again,
that-
she lays out all of the things that she does as a supervising analyst. And in the report, at least as part of the direct examination, the counsel didn't approach the witness with the report until some time into her examination already. So that you say that she's essentially reading from the report. She didn't get the report.
We have, I think, if you look at transcript, volume 576 at line 8, I think she says she's reading from it, which is,
Right, but it was preceded by counsel approaching her with the report. Right?
At this point, Your Honor, your information is as good as mine. I'm making the concession because it appeared to me to be the case that we took the shortcut here and didn't do this properly. But that's the error. That it shouldn't have been done that way, but as I say, in this case, it appears to be harmless. I would note the error has, I mean, this is clear error long before Smith v. Arizona came down.
Can you walk us through, in your opinion, how post-Smith v. Arizona this evidence could have come in through what evidence could have come in through Ms. Hart and how?
My reading of Smith v. Arizona is that it does not change what we do in Massachusetts, that the error identified in Smith v. Arizona would have been an error in Massachusetts under.
So how do you deal with what Justice Kagan says, or the court says, at pages 798, and apologies, I'm going to just read for a minute because I think it's the heart of the question. I'm just going to say the substitute expert instead of the name. And likewise, the jury could credit the substitute expert's opinions identifying the substances only because it too accepted the truth of what the actual expert or the analyst reported about her lab work as conveyed by the substitute. If the original analyst had lied about those matters, the substitute expert's opinion would have counted for nothing, and the jury would have been in no position to convict. So the state's basis evidence, more precisely the truth of the statements on which its expert relied, propped up its whole case. I understand, Justice, the court to be saying there that the substitute experts may have had all sorts of expertise and may have been able to say various things looking at dry papers, but the relevance of that expert's opinion entirely hinged on whether the original analyst actually did the wet lab work properly, and that analyst was not in court and was not confronted on all of that, so the substitute opinion could not come in. Is that, do you think, an incorrect reading?
So I think you're getting at the deep question that this case presents, and I'm not sure, I will present what I think is my answer. As I said, my reading of the case on its facts is that if that case had been in Massachusetts, this court would have reversed for the same reason, because the basis, not just the basis inference, but the basis testimony is being offered by the substitute, and that would be impermissible. That would already have been impermissible in Massachusetts. The deeper question is whether Justice Kagan means for us to understand that even where the basis evidence is implicit and never stated, it still is sort of hidden hearsay that taints the testimony of the substitute.
As to the final conclusion, right? As to, yeah. Because the final conclusion of the testifying expert relies on the underlying testing and the accuracy thereof.
Right.
Right, so I think one of the reasons, well, I don't know why Justice Gaziano started with prejudice, but so it does make a difference, though, if this is just an evidentiary error versus a confrontation clause error. So under
it doesn't change the standard of review, Your Honor. It's still a substantial risk.
Why do you say that? If it's a
because
I thought under
there's
Vasquez,
cases that say that even a confrontation clause error, if it's not objected to, you still get, you don't default to harmless beyond a reasonable doubt analysis. You still get a substantial risk because you failed to note the error. And here, especially where,
but here, so you're saying because the defendant should have objected on evidentiary grounds.
Right. I mean, it goes beyond that here.
It doesn't. We don't get the benefit of cases like Vasquez, where there's a confrontation clause error as well.
If I'm following you, yes. The answer is you still don't get the more favorable standard of review merely because it is a Sixth Amendment claim. the confrontation.
This does case, though, this situation does bear striking resemblance to Vasquez, that does it not, however, where we have Williams and then we have Greinader, or however we're calling it, which is very similar to what was the situation in Vasquez, correct?
Yes.
But you're saying because there was a separate error, related separate error to which he clearly should have objected or could have known he should object, therefore he doesn't get the benefit of Vasquez?
So I'm saying more than that. I'm saying it's my brother's representations notwithstanding, the defense clearly wanted this evidence, right?
Right, and so then maybe it's harmless beyond a reasonable doubt, but that, I read Vasquez as being on all fours on this in terms of whether or not this, the standard of review was harmless beyond a reasonable doubt and not substantial risk. The question here is, because there's an overlapping evidentiary objection, does our review default to substantial risk?
I think I can't answer that beyond what I've already said.
Well, part of the analysis in Vasquez was that it would be fundamentally unfair to penalize defendants because the SJC had this ruling that made their objections futile. It strikes me that you have a good argument here that it's not fundamentally unfair here, where it was the defendant who himself really wanted to get this evidence in.
Right.
But if we assumed that away and we were thinking of the more ordinary DNA case where the Commonwealth just put in the DNA, no one wanted, the defendant didn't want it in, that would be a different case.
This is a completely anomalous case, right? Well, I mean, this is the ordinary substitute analyst case is we're the proponents and want the evidence, and the defendant does not. This is the reverse. We moved pretrial to exclude it, accepted it reluctantly, and the defendant has sort of seized on it and made it the centerpiece of his defense. So it's kind of backwards to the way this kind of thing usually goes in. I think for that reason we prevail under any standard of review on the narrow question of what happens here, on the question of the potential significance of Smith v. Arizona. Again, I think my read of it is that case would have gone down the same way in Massachusetts for exactly the same reason, which is the mistake of expressly conveying, essentially restating, the substitute restating the analysis of the missing analyst. That would be problematic here.
Well, can I read some more of the opinion to you?
Yeah,
so at the end, Justice Kagan sums up, neither may the state introduce those statements through a surrogate analyst who did not participate in their creation, and nothing changes if the surrogate, as in this case, presents the out-of-court statements as the basis for his expert opinion. Those statements, as we've explained, come into evidence for their truth, because only if true can they provide a reason to credit the substitute expert. So a defendant has the right to cross-examine the person who made them.
Can I try getting at this by just taking us back to the concerns that underlie, especially in the context of DNA evidence, where really much of the process is automated and done by computers and very sophisticated machines. It's the human error, inadvertent or deliberate, that we want to be able to get at. And you can't know in advance, particularly in a case where we, as here, the substitute is both the supervisor and the technical reviewer. We can't know in advance merely from the fact that implicit in the conclusion is some work of the non-present analyst. We can't know that the possibility of getting at mistakes is inaccessible to cross-examination until there's a cross-examination. We need to find out what that substitute actually knows. To take a very extreme example, it's here Jessica Hart testifies, I didn't conduct the test, Kira Snyder did, but what if the follow-up question is, well, were you in the room? Yes, I was. Did you see it? Yeah, I was kind of leaning over her shoulder. She did it because she's new, or I'm just making that up. But that's an instance where she'd be able to testify from direct knowledge. So. But also, it may be that even in a case where she can't do that, she could testify to the fact that there are protocols in place in the lab that would prevent the kind of mischief that the defendant might be expressing concern about. That what's the possibility that the known sample, the buccal swab, could have been used to taint the sample that's being tested? Is that possible? Well, there may be reasons why that actually could not have happened. but you have to explore that through actual cross-examination. My concern in the language that you're reading from Smith v. Arizona is it seems like a mistake to assume that the most extreme interpretation is the correct one, that it essentially forbids any testimony where there's implicit basis. Was it Justice George's whose question kind of got at that same point, which is there's always something down there. There's always additional information, and at what point do we stop then? So I think first of all, I think you should just duck the question here because I don't think it's correctly presented on these facts. To the extent you take it up, I think there's no reason to get ahead of where the case law is. As I say, Smith v. Arizona it's entirely consistent with what we're already doing on its facts, because whether or not it means to suggest deeper concerns about implicit basis testimony, on its facts, it's about explicit basis testimony. That would not be appropriate here. So I think where we stand on this is, yes, there was an error here. Yes, it's harmless by whatever standard you employ. And leave the ambit of Smith v. Arizona to a better case, I think would be the Commonwealth's recommendation.